హేగ్లోని అంతర్జాతీయ న్యాయస్థానంలో కుల్భూషణ్ జాదవ్ కేసు విచారణ జరుగుతోంది. ప్రత్యక్ష ప్రసారం ద్వారా చూద్దాం.
avait été confirmée par le chef de l'état-major du Pakistan, comble de l'ironie, plus tard, alors que cette condamnation avait été prononcée et confirmée, l'Inde a reçu du Pakistan une note verbale réitérant que la possibilité de communication consulaire serait accordée en contrepartie de l'Inde.
The non-mention of death sentence reflected the farcical nature of the proceedings and so-called trial by a Pakistan military court against Mr. Jadhav. Despite requests by India, Pakistan has not provided any information or documents, including the charge sheet, proceedings of the court of inquiry, the summary of evidence, the judgment. Request for appointment of a defense lawyer for Mr. Jadhav has also not elicited any response. The mother of Mr. Jadhav, even in the absence of any document, submitted an appeal to the Court of Appeal and a petition to the federal government of Pakistan. This appeal was filed even though it was unable to address any of the issues that may have been put against Mr. Jadhav in the judgment and order of conviction. It was an act of desperation by grieving parents. The parents of Mr. Jadhav applied for visa on 25 April 2017 to travel to Pakistan. There has been no response. The Minister of External Affairs of India has written to the advisor to the Prime Minister of Pakistan on Foreign Affairs on 27 April 2017 for his personal intervention in the matter, but there has been no response. All that we know is what we have seen in the media in Pakistan. Pakistan officials have been reported as having said clearly that Mr. Jadhav would not be provided consular access. Mr. President, members of the court, India believes that a farcical nature of the proceedings and unjust trial by a Pakistan military court in egregious violation of the rights of consular access under the Vienna Convention has led to serious miscarriage of justice. It is clear that Mr. Jadhav has been denied the right to be defended by a legal counsel of his choice. He has not been informed of his right to seek consular access. His conviction and death sentence appears to be based upon quote-unquote confession taken in captivity without proper legal representation and in absence of consular access sought by India. If we closely follow the reports in the media in Pakistan, we can get the sense that an increasing number of death sentences awarded by military courts in Pakistan have been carried out after 10 April 2017. That's when the death sentence to Mr. Jadhav was confirmed. In fact, over the past 1 month, 18 such executions have been reported through press releases issued by the Inter-Services Public Relations, the military spokesman of Pakistan. In such circumstances, including where there is no response to the requests made through diplomatic channels, there is an immediate threat that death sentence against Mr. Jadhav may be carried out even before India has the opportunity to be heard and the court has the chance to consider the merits of the case, and thus causing irreparable prejudice to the rights of India and Mr. Jadhav. Mr. President and the members of the court, India has invoked the jurisdiction of the court and sought provisional measures. My colleagues will elaborate further on this. I would now request the court to invite Mr. V.D. Sharma, co-agent for the Republic of India, to make his submissions. Thank you.
Merci, monsieur. Avant de donner la parole au co-agent de la République de l'Inde, le Dr Sharma, je demanderai aux plaideurs de bien vouloir ne pas parler trop vite, de manière à permettre aux interprètes de faire leur travail de traduction dans l'autre langue officielle de la Cour. Je les en remercie d'avance. Monsieur le Dr Sharma, co-agent de la République de l'Inde, vous avez la parole.
Mr. President, distinguished members of the court, it's a great honor for me to appear before this court as co-agent of the Republic of India in the case concerning the violation by the Islamic Republic of Pakistan of the Vienna Convention on Consular Relations, 1963. I propose to devote my observations to the key issues which would be addressed in elaboration by my colleague, Mr. Harish Salve, concerning violation by Pakistan of the rules of international law, which led to the dispute at hand, justification for the grant of urgent provisional measures, and this court's jurisdiction. Now, Mr. President, I draw your attention to paragraph 5 of my statement in front of you. Mr. President, members of the court, the convention sets up, among other things, standards of conduct concerning consular relations between states, with the view to contribute to the development of friendly relations among them. The provisions Under Article 36 of the Convention specifically confer rights of consular access and communication upon the sending states and their nationals who may be arrested, detained, or put in prison in the receiving state. These provisions were interpreted by this court in the Lagrand case, Germany versus United States, and reiterated in the Evna case by this court, what this court said in the Lagrand, and described Article 36, paragraph 1 as an interrelated regime designed to facilitate implementation of the system of consular protection and set out again the scheme of Article 36. Mr. President, members of the court, Article 36, which has been recognized as a right of the national of a state and also the right of the state itself, is a vital safeguard that ensures a modicum of fairness in the administration of justice system of a state in its application to nationals of another state. Its provisions are sacrosanct and its violation entails serious consequences. Mr. President, members of the court, Pakistan failed to comply with all its obligations under Article 36. It denied India its right to consular access and to its nationals. India has been seeking consular access incessantly since March 2016, when India was informed of the detention of Mr. Kulbhushan Jadhav by Pakistan.